were a federal prosecutor for a long time, whether, when, and how the prosecution gets information with the defense goes directly to the integrity of our legal system, as Senator Seitz first set the groundwork. I think it was one of your deadly sins. Defense counsel have limited tools at their disposal, and unfortunately, in the typical criminal case, often have very limited resources to conduct their own investigation. If the prosecution, for whatever reason, fails to disclose information favorable to the defense, this may well mean that it never comes to light. Oddly, prosecutors really have a dual role in this country. Although they are ultimately seekers of justice and truth, they are, of course, tasked as a primary matter with seeking the conviction of those that they believe personally are guilty of crimes. That is unfortunately a function that can be influenced by passions and prejudices. Tell us what we should be doing to ensure that the player in the system that we've all talked about today really has the most power, is exercising their judgment with the utmost integrity.
I represented both Arthur Anderson and Merrill Lynch executive in some of the Enron litigation as a defense lawyer. Until that time, I had been inculcated in the notion that the job of the United States Attorney is to seek justice, not convictions. I'd worked for 9 different United States attorneys from both political parties in 3 different districts across the country, and not one of them would have put up with anything short of that. So the tone set by the district attorneys or the United States attorneys and the Attorney General is extremely important. Unfortunately, as publicity for prosecutions has increased, so has the taste among some prosecutors for self-aggrandizing and promoting their own political careers at the expense of doing justice as opposed to seeking convictions. The famous Michael Morton case in Texas you might have heard of. Michael Morton wound up spending 25 years in prison for a murder he did not commit. He was accused of murdering his wife. The prosecutor who had convicted him ran for state judge on the premise that he had convicted Michael Morton, who had killed his wife. Meanwhile, that prosecutor had hidden exculpatory evidence, including a bloody bandana that contained the DNA of the real murderer. Yes. And the prosecutor became a state court judge in Texas. Michael Morton, thanks to the Innocence Project, is out of prison, and thanks to God, is not bitter and has gone around trying to help reform the system. But for a prosecutor to be able to achieve a hideous injustice like that and then become elected a state judge is just beyond my comprehension. And on top of that, the Innocence Project had to fight for 6 years to get a DNA test for Michael Morton because the successor prosecutor was covering the butt of the first one. So I agree wholeheartedly with mandatory DNA testing paid for by the state upon request. It should not take 6 years to get a DNA test for anybody who complains they're innocent. In the process of representing the Merrill Lynch and Arthur Anderson defendants, I learned that prosecutors these days are making up crimes, so I also second the import of defining very carefully what you want a crime to be and including the mens rea element. That's extremely important. And I also shockingly learned, to the point of making me physically ill, that prosecutors, these very high-profile prosecutors in these high-profile cases, including the prosecution of Senator Ted Stevens, had hidden exculpatory evidence. In the Merrill Lynch case, they had actually yellow highlighted it pre-trial as exculpatory evidence favorable to the defense, and then hid it for 6 years, while 4 Merrill Lynch executives went to prison on an indictment that did not even state a criminal offense. And while the prosecutors hid the evidence, they had yellow highlighted. Those prosecutors then became Chief White House Counsel, General Counsel Deputy Director of the FBI, and the Acting Attorney General for the Criminal Division of the Department of Justice, who then also micromanaged and corrupted the prosecution of Senator Ted Stevens. So that is the story told in my book of those particular prosecutors and how they became who they became. Without anyone knowing what they had done for the most part for a long, long time. And you still can't get this story anywhere but in my book. There's been a significant effort to tamper and keep down the news of this discovery to the point that the New York Post was going to write an article about my book, reached out to DOJ for comment, and decided not to write the article. So there is significant pushback, and there will be from prosecutors and from, and the State Bar of Texas wouldn't let me speak on it. Ironically enough, even though they had just corrected the Michael Morton injustice, and I thought they would do something about this because one of the prosecutors was a Texas lawyer. The bar did absolutely nothing about it because at that time he was acting Attorney General for the Criminal Division of the Department of Justice. Yeah. So yes, there will be DOJ pushback. Senator Orrin Hatch has certainly experienced that in the wake of the Michael Morton case and in the wake of the Enron and actually the Ted Stevens prosecution. Judge Emmett Sullivan in the District of Columbia appointed a special prosecutor to investigate the Department of Justice. And at the same time his report came out, there was a massive bipartisan effort to introduce what's called the Fairness and Disclosure of Evidence Act. 3 Democratic senators, 3 Republican senators sponsored that legislation. It was supported by the NAACP, the ACLU, every bar association in the country. The only opposition it received was from our now ironically named Department of Justice, and it died on the vine. So why?
Cindy, have there been states that have been more successful than that federal effort?
There have been. North Carolina and Texas, my 2 home states, and Ohio now have done good things in that area. So the idea is to sponsor and pass legislation that does require prosecutors to produce evidence favorable to the defense without regard to its materiality. That's where prosecutors really want to play games. They say, it's not material to the defense. Well, even good prosecutors, the ones that want to do the right thing, and there are a lot of those, thankfully they're in the majority, they don't know what's material to the defense. Only the defense is going to know what's material to the defense. And the Brady Rule, as it's called, that started all this to begin with from the Supreme Court's decision in Brady versus Maryland, intended the materiality issue to be used by an appellate court to decide whether it was so important the conviction had to be reversed. It wasn't intended to decide whether it's produced to begin with. So your legislation should simply require production by the prosecutor of all evidence favorable to the defense. You will get massive pushback from that, but they can do it. They know what the Brady Rule is. I call Brady the oh shit rule. You look at the piece of paper or hear the evidence and you go, oh shit, maybe I don't have a case. And GIGWO, which is related to that, requires prosecutors to produce evidence that would impeach any witness. And I call that the damn rule. Because you just kind of go, damn it. But prosecutors know what it is. They don't have any trouble realizing what it is. And they have an obligation to seek it out and to produce it. But you can help a lot by that sort of legislation. Also, I think we need to abolish prosecutorial immunity. Prosecutors have absolute immunity. Police officers work every day under qualified immunity. There is no reason for prosecutors to have immunity when they intentionally withhold evidence they know is favorable to the defense. And that is the issue I am speaking all around the country about, because there are prosecutors that intentionally withhold evidence favorable to the defense. You cannot yellow highlight something as Brady pre-trial and then surgically excise the key words from the little 4-line production you give the defense of hundreds of pages and it not be intentional. These were the best and brightest lawyers from the best and brightest law schools, and they knew exactly what they were doing, and they did it for 6 years. So I think if we took away their absolute immunity, there would be far less incentive for prosecutors to do what these folks did.
Thank you, Sid.